Last month, the Honorable Supreme Court of India decided a writ petition which was called as writ petition number 202 of 1995, TN Gaudavaram Tirulpad versus Union of India and others. This was a three-bench judgment decided over by Honorable former Chief Justice of India. This was under the inherent and original jurisdiction of the Supreme Court of India. If you read the judgment, the very opening headline of the judgment says this is regarding the issue relating to definition of Aravalli hills and ranges. So the judgment primarily defines what is a Aravalli hill and what is a Aravalli range. There are two different things. It is not a single word, Aravalli hills and ranges. So the definition has been defined there. Firstly, the Aravalli hills spread in 4 states of India. That's Haryana, Rajasthan, Gujarat, and Delhi. The need was to have a uniform definition of what these hills constitute, what these ranges constitute for all the 4 states. So the Supreme Court had to step in. Now, these are the oldest fold mountains in India, Aravalli Hills, and one of the oldest geological feature on the map of the world. The Aravalli Hills have got a very rich flora and fauna. There are around 22 national parks, approximately 5 tiger reserves, including the famous bird sanctuary of Koila Dev. It is very rich in biodiversity, the Aravalli Hills. And majorly, it acts as a barrier spread of the Thar Desert, which lies in the state of Rajasthan, to extend beyond Rajasthan into the states of Uttar Pradesh and Haryana. Now, the other aspect why Supreme Court had to intervene was there was a United Nations Convention on combating the desertification, to which India is a signatory, and India ratified this document. Now, according to this document, the countries who were signatories to it and who have ratified it were supposed to make new laws, amend the existing laws towards the goal of trying to control the desertification across the geographical land of India. Now, India signed this treaty on 17 December 1996, and this was another reason why Supreme Court had to sue Motu on its own, take up this matter. Now, the judgment actually, if you read between the lines, has prohibited completely and excluded the mining activity from the core area of the forest, the buffer zones, the reserved forest areas, special economic zones, the special zones which were created and demarcated. Only selective mining, which was going on for a long time, has been regulated and has been strictly brought under the purview of the state governments to be further regulated, and no fresh mining leases are supposed to be given. So the question of trying to flatten out the Aravalli Hills does not arise at this stage. And there was a committee which was directed by the Supreme Court to go and define as to what constitutes the Aravalli Hills and Aravalli Ranges. Now, this committee came out with several recommendations, apart from, of course, trying to preserve the environment and biodiversity of Aravalli, which was primarily the task of the committee. And the Government of India Constituted Committee gave several recommendations to the Supreme Court, which the Supreme Court primarily agreed with. Now, one of the definitions which has caused a lot of anguish and a lot of anger among the people who are environmentalists and green soldiers is the definition of Aravalli Hills. Now, if you look at the definition of Aravalli Hills as given by the committee was any hillock or hill, if its height is more than 100 meters, would only constitute the Aravalli Hills. So, the contrary would apply, saying that anything below 100 meters can be totally flattened out, given for commercial development, or changed. The entire landscape could be changed. But if you look at the technical reading of what the committee has suggested, though I am not an engineer nor I am a geologist, but what I feel is there is another explanation given in the same paragraph, which says the extension of 500 meters from the lower contours of the hillock or the hills of Aravallis extended, if it includes the other hills, that also would form the part of the Aravalli ranges. Now, this clause actually encompasses very comprehensively the entire range. I don't think it is very, very difficult practically to identify areas which are less than 100 meters and try to do any other activity, because the contour area, if it is included, 500 meters is a very small area. So it would be practically impossible for the governments to go for mining in these areas which are less than 100 meters. So by any means, I feel this judgment of the Supreme Court, in fact, I feel is a very positive step in trying to establish that the biodiversity of the Aravallis is well protected, and the mining leases would not be easily given now unless they are regulated. Though the mining activity has been going on for a very long time. If you see the famous Makrana marbles, which also comes from the Aravalli ranges, we all know how sought after that stone is, and it is used all across India. It's sold all across India. So the mining activity is going on. It is not that it has started recently, but the only thing is now it would be very regulated in a very selected areas which have been identified by the committee, and unchecked mining activity would stop by this order of the Supreme Court. Now, this is just merely my interpretation of the Supreme Court order, and I feel there is no reason for all of us to panic at this stage. This apart, as I said, the Supreme Court, the Honorable Supreme Court, has always been concerned about the environmental issues. If people recollect recently, the order of the Supreme Court in banning night safaris across the tiger reserves in India, banning the enclosed safaris across India in places like Bannerghatta and Gir forest, where the inside the core zones, the enclosed areas were there where wild animals were left, and then people were taken on vehicles to go for a safari. So the visibility is like assured for them. So these kind of activities, which are quite unnatural, in fact, they are not very natural way of sighting the animals, has been stopped by the Supreme Court. And I personally feel there is no need to despair at this stage, or try to throw ourselves up saying that everything is lost, the mountains are lost, the ecosystem is lost. And let us have faith in the judicial system, which I'm sure, given the voice of the people, the concern of the residents there, can always revisit this judgment. There are several judgments of the Supreme Court, which the Supreme Court has got inherent powers under the Constitution to review them. I'm sure if anything of that sort happens, the Honorable Supreme Court would take cognizance of it and review its own judgment, so that no damage, existing or future, is caused to the Aravalli Hills and Aravalli ranges. Thank you so much.